election, he is permitted to, sorry, Your Honor, I'm just getting a message here I want to clear out. He is permitted to vote in the county where he moved from, where he was registered, which was Forsyth County. That is exactly what he did. The reason that's the law is because there's an election going on. It's and at the end of the day, we want to ensure people can vote. And so Mr. Blackman followed the law there. That's not how that finding of fact was used in the conclusion of law in the final decision here, though, Your Honor. It was actually used against him in paragraph 10 of the final decision, the conclusions of law. The secretary held that because he voted in Forsyth County in the November election, he clearly intended to remain in Forsyth County and not be a resident of Fulton County, and did not take into account 21-2-218, and therefore it was a clear violation. Your Honor, I'll also just add in passing, we also mentioned in our brief, and the Secretary of State responded, that there in the findings of fact, there was reference to the fact that Mr. Blackman's family continued to reside in Forsyth County. There was testimony in the record and in the findings of fact show that his family had the intention of his children were finishing school in Forsyth County, and then Mr. Blackman and his wife planned to move the family to Fulton County, to Atlanta at the end of the school year. Mr. Blackman moved early. He moved in October. And the findings of fact reference the fact that his family remained in Fulton County, and therefore that must have some bearing on his intent. However, there is another specific Georgia Code section, 19-2-3, that says Mr. Blackman's residence, his domicile, can be different than his wife's domicile. And in fact, his wife's domicile, his family's domicile, has no bearing on what his domicile is. And that was noted also in the Dozier case, which is cited in our brief, and I believe in the Secretary's response as well. I thought it was noting in the Secretary's response brief on page 16, they basically said the Secretary did not even consider his wife or family's domicile and used that against Mr. Blackman, but then said, quote, had petitioner's family moved with him, it would have been affirmative evidence of his residency in Fulton County. His family having remained in Forsyth County is simply another missing piece of petitioner's affirmative case. So the Secretary did use that against Mr. Blackman to show, to bear weigh on his intent, which was impermissible considering that code section, Your Honor. Your Honor, I'll move to the second subsection, the clearly erroneous subsection.
Yeah, you got about 3 minutes.
And try to zip through this. Most egregiously, Your Honor, the Secretary excluded all the testimony of Mr. Blackman's intent. And that is a key provision, a key part of the analysis for the Secretary here for the determination of domicile, because you have to show both removal from Forsyth County and Mr. Blackman's intent to remain in Fulton County. That was a finding of fact that was not used in the conclusion of law, and therefore, based on the whole record, it is clearly erroneous. The Secretary also found that Mr. Blackman's testimony was, quote, uncorroborated, and we have cited to a myriad of evidence, a myriad of exhibits of 4 witnesses testified at the hearing. None of that was refuted at all in the evidentiary record, Your Honor, and all served to corroborate the affidavit that Mr. Blackman signed, attesting to the fact that he intended to remain in Fulton County as of October the 11th of 2024. And finally, Your Honor, our final provision is the arbitrary capricious subsection. And most notably here, the Secretary held that Mr. Blackman did not furnish the Coleman Street property, despite all the testimony, the photographs of the furniture, the art, the myriad of things that he moved into this apartment in October of 2024, the secretary said, well, even if I consider all of that, even if I take it at face value that those items were moved into the apartment, it still wouldn't be furnished, and provided no legal authority or basis for what would qualify as being furnished. And therefore, we argue, Your Honor, there was no rational basis for that. It therefore was arbitrary and capricious. And based on all of those, we would pray that the court reverses the final decision, allowing Mr. Blackmon to be a candidate in the race.
All right, thank you, Mr. Wilson. You've got about a minute left in rebuttal if you wish to use it. I'll go ahead and shift at this point in time to the ladies from the AG's office. Which one of you is going to argue?
It'll be me, Ms. Noonan, Your Honor.
All right, Ms. Noonan, you can go ahead and get started.
Thank you, Your Honor. In support of his argument for residency in PSC District 3, the petitioner has offered largely uncorroborated testimony regarding his intent to reside there at the Coleman Street property, as well as the extent to which he actually removed himself from his home in Forsyth with the intent to remain indefinitely in Fulton County. As we just heard from petitioner, it is his burden to affirmatively establish that he has residency in District 3. And I'm quoting the Georgia Supreme Court in Queens v. Wells. The secretary is not required to disprove anything. Our counsel for petitioner has already discussed the two-step process, so I'll leave that out. But I would note that the court is limited both to the record under OCGA 21-5E and to the grounds enumerated in the petition, and we cited to Department of Public Safety v. Bell in our brief. So as to that first point, failure to consider all the factors within 21-217A is not one of the grounds that's enumerated in the petition. There are mentions here of failure to properly consider certain evidence or improperly limiting certain evidence, but the extent to which the secretary didn't respond to the parts of the 21-217A test, 1, 3, 4.1, 6, 7, and 9, that is not enumerated in the petition. And so it's not something that Your Honor should consider here. But moving on to the points that were articulated in the petition, actually, I'll start first with petitioner's affirmative case. So as we discussed, it's petitioner's burden to establish residency. And to that point, Mr. Blackmon's affirmative case is very thin. At OSA, aside from his testimony, he presented a 6-month short-term lease of the Coleman Street property. He presented photographs of his belongings, a limited amount of furnishings, but largely personal belongings, in a storage unit, not in the Coleman Street properties. There are no photographs in the record of the furnished apartment. He presented testimony of Ms. Asia Thomas, who is his realtor, about a discussion that they had in 2022 regarding his eventual intent to move to Fulton County. But he did not at that time purchase any property in Fulton County or acquire any leaseholds. His son's admission to a college in Atlanta and his ultimate updating of his voter registration in April of 2025. So all these facts are as consistent with someone who has a temporary residence in Fulton County as they are with someone maintaining a permanent residence, if not more so. And as the Supreme Court of Georgia explained in Dozier, one can have multiple residences, but only one domicile. What Mr. Blackmon did not present is any of the evidence that we typically see in a successful candidacy challenge, and nothing that was mentioned or contemplated by OCGA 21-217A15, which would be, quote, significant mails, such as personal bills or other evidence that indicates where the person resides. So he did not change his driver's license. He does not appear to have used the Coleman Street address on any of the loans he took on the Forsyth home. He does not appear to have registered any vehicles in Fulton County. He does not appear to have used that Coleman Street address on any tax documents. He has no voting history in Fulton County and did not change his voter registration until April 3rd of 2025 when he attempted to qualify for this race. On the other hand, Mr. Blackmon has continued, and he did testify to this, to receiving mail at his home in Forsyth, where his family lives. He paid bills and taxes on that property. He remained registered to vote there. And so the secretary, having considered the weaknesses of petitioner's affirmative case and the evidence of his continuing to reside in Forsyth County, concluded that Mr. Blackman had not met his burden to establish residency as required under OCGA 46-2-1B. Moving to the points that are articulated in the petition. First, that the secretary have failed to account for 21-218E. That's the statute that permits an individual who's moved within roughly 5 weeks of the election to vote in their current county. That was not applied at all in the final decision. And the final decision, regardless of what counsel may have said at the OSA hearing, what the ALJ wrote in the initial decision, and therefore the secretary adopted in the final decision, is that it's not just that he voted in Forsyth in that election, it's that he remained registered in Forsyth County until April of 2025. Put differently, he has no voting history in Fulton, and no voter registration history until the date he attempted to qualify. And 21-218E does permit electors who move close to the election to vote in the county in which they're already registered, but it does not stop an individual from changing their voter registration. And the county would simply change his precinct after the election were over. To the extent that petitioners allege the final decision failed to offer evidence inconsistent with the petitioner's claim that he changed his residence, at the outset, that is incorrect. The final decision cites several factual findings that are inconsistent with a move of residence to Fulton County. And I've already listed some of them: that he continued to receive mail in Forsyth, paid bills and taxes on the property, took partial claims mortgages with that address listed as his home address, separate from the address of the property, remained registered to vote there, and more. But more importantly, as we said, and as petitioners agree, the secretary is not required to disprove anything. There is a line in Dozier that recognizes that the challenger in that case had not identified any evidence that was inconsistent with residency in the relevant district in that case. But that comment was made not to shift the burden back to the challenger, but it was made against the backdrop of a really strong affirmative evidentiary case. That individual had a changed driver's license, a voter registration history, a 10 election voting history, ownership of real property, a homestead exemption, jury service, more. So that candidate, having satisfied his burden, if the challenger is unable to refute any of that evidence, then that is obviously very relevant. As to the point on domicile, the secretary's response does not say we didn't consider domicile. It says we did not presume his domicile to be the same as his wife's. Although OCGA 19-2-3 prohibits a presumption that spouses share the same domicile, it does not prohibit the hearing officer or the secretary from considering where his family lives. In this case, a factual finding on where his family lived was necessary to understanding his testimony, but also had his family moved, it would have been another element of his affirmative case. So its absence is relevant here. None of that amounts to a presumption that he shares a domicile with his family. In terms of some of the clearly erroneous points, specifically the secretary's alleged failure to consider or his exclusion of testimony of intent, it's not that that was excluded, it's that it was considered and not found persuasive on its own. Because we don't have things here like a changed driver's license, voter registration history, vehicles, anything like that, what we're looking at is largely uncorroborated testimony. It's not that that wasn't considered, it's simply not persuasive on its own to the ALJ or the secretary. And then that's for two reasons, Your Honor. First, 21-217A sets out 15 different factors to consider in considering domicile, and it specifically includes things like significant mail and documentary evidence. So to the extent that the General Assembly thought that, the candidate's own testimony would be sufficient, if they probably would not have articulated a 15-part test. And number two, that testimony is uncorroborated. In the petition, paragraph 33 sets out a number of possible ways to corroborate the testimony, but none of them actually does this. Some of these in paragraph 33 are referenced to petitioner's testimony. So his testimony obviously can't corroborate itself. The existence of a 6-month lease, that is unhelpful. A short-term lease does not corroborate as necessarily an intent to change residence. Same with the furnishing, the photographs of the furnishings. They do not show any of those items in the property. And even if they did, the majority of those items pictured seem to be personal items, storage bins. There's some limited furniture pictured, but as the ALJ said, he and the secretary who incorporated it by reference would not consider that furnished. Even if the property were furnished, an individual would furnish a second home, an individual would furnish a computer crash pad. Other alleged, aspects of corroboration, Ms. Thomas's testimony, that is a discussion they had in 2022 about his amorphous future-looking intent. She may have shown him properties in Fulton County. He did not purchase any of them. He went on to purchase a property in Forsyth and didn't secure this leasehold until 2024. As OCGA 21-217A9, intent without removal is not sufficient. So even if he had manifested the intent back then, he had clearly not removed to Fulton County because he went on to purchase a home in Forsyth that he did live in. In terms of, I believe it was the points that just moving on to the other points that we didn't necessarily discuss in as much detail, but were mentioned in the petition. Using the Forsyth property to secure loans. I don't believe that the ALJ called these quote unquote new loans, even if Judge Cabrera had said that. It's not the nature of the loans that's relevant here. It's the fact that taking loans on the Forsyth property constitutes additional ties to that property. And if you look in the record, Your Honor, the latest of these is signed February 18th, 2025. It's at OSA 127.
Ms. Noonan, you got about 4 minutes.
Lists the petitioner's home address as the Forsyth property. It's listed separately from the address of the actual property that they are receiving the partial claims mortgage on. So you had an opportunity there to list his new address as being in Fulton County and didn't do so. To arbitrary and capricious. The standard for arbitrary and capricious is a decision is only arbitrary and capricious if there's no rational basis for the agency's decision. And the final decision clearly lays out the reasoning for the secretary's determination here. And that reasoning is that the affirmative case, which is Mr. Blackman's burden, is based largely on his own personal uncorroborated testimony. The documentary evidence that is supported or that was submitted is limited and is unhelpful largely. And so that's the reason he's failed to meet his burden. And then as a secondary point, the final decision concludes that there is evidence that he continued to reside in Forsyth County. That may not be the secretary's burden, but it is something that the secretary showed. And to one final point, Your Honor, and then I'll wrap it up. The witnesses that testified, none of those witnesses had any actual knowledge of this residence at all. So to the extent that their testimony was disregarded, that is because it is unhelpful. This is not a hearing about Mr. Blackman's participation in the Fulton County community. This is about his residence. And it does seem that there might have been someone who could have corroborated that, who testified to holding social gatherings at the apartment. None of those individuals testified. So none of the witnesses had any actual knowledge of residence. One final point on counsel's original point on failure to consider all the factors. It's not that all the factors weren't considered. It's that the initial decision, which is incorporated to the final decision, discusses only the factors for which there was relevant evidence. Obviously, all 15 parts are not always going to be relevant to every case. And so the parts that were focused on were the aspects of the rule that were most relevant here and for which some relevant evidence was submitted. Thank you, Your Honor. I'll end it there.
All right, you got about 2 minutes left. All right, Mr. Wilson, you can use your 1 minute.
Your Honor, first I want to address what Ms. Noonan said about the ground not being raised in the petition about the certain subsections of 217 that the secretary did not take into consideration. This case that they cited in their brief, if you read the case, it cites to Code Section 50-13-19, which says the ground that you have to specify in the petition is what I enumerated with you, Your Honor, at the beginning of my argument, that it was clearly against the laws of this state. That's the only ground you have to specify in the petition. The next thing I want to address is Ms. Noonan said the evidence was all uncorroborated. All the evidence in the record is consistent. And this is why we have this review, Your Honor, because it's not good enough for the secretary just to say, well, that's not good enough, that's not good enough, that's not good enough, that's not good enough. And Mr. Blackman being the only one putting any evidence up, none of it being refuted. If you look at the Dozier case, which we have cited, if you look at the Davis case, which we have cited, Your Honor, and if you look at one of this court's most recent decision in the Mahone v. Raffensperger case, which we have cited and will provide to the court after this hearing, where all the evidence is consistent with the affidavit that Mr. Blackman signed to become a candidate. Essentially, it's a summary judgment standard, and he should be held to be duly qualified. What more does the secretary want? He has followed the law here, Your Honor.
Let me let you address a couple of different things. It looks like from looking at 21-2-17 rules for determining residence, it's the rules shall be followed so far as they are applicable. So I don't think you have to tap each rule. It's just whichever one of the 15 subparts the judge decides are applicable in the circumstance. And the second thing I would just say is to you, and I'll just have you address these two issues, is isn't the court bound to accept the secretary, I mean, not secretary, but the judge's determination of the facts and credibility of the witnesses? Meaning that I have to accept whatever the judge, the ALJ, kind of looks at. Is that true?
I'll address those in turn, Your Honor. I'll start with the 21-2-17 factors. And you correctly highlighted that the court is only, and the secretary is only required to consider the ones that are applicable.
Okay.
That is true. The Supreme Court held that in the Handel v. Powell case. However, it's not the ones that the secretary decides are applicable. It's what the record, which are indicated in the record.
Yes.
And if you look at the case law interpreting that code section, it's very explicit about that. And where the secretary has declined to consider subsections that are implicated in the record, the Supreme Court has held that the secretary's final decision should be reversed because it had the effect of holding up certain of those subsections over others, which is improper.
Is that a like, for example, if I note those factors, okay, or they're applicable, is the fact that I don't consider those factors detrimental? Or are you saying that because that the ALJ should have considered these particular factors because they were presented?
Because they were implicated in the record. Based on the evidence that was in the ALJ's findings of fact, they were implicated. And, my learned colleague, Ms. Noonan, mentioned, it's not that they weren't considered, they just weren't included in the final decision. Well, this court, it must assume if it's not included in the conclusions of law that it was not considered, because this court can't read into what the secretary or the ALJ did if it's not considered, I should say, if it's not explicitly contained in the final decision.
Okay, so you're saying that the judge, even though the 15 factors are factors that the judge can consider, that if he doesn't address them in the particular, if evidence is presented of one particular fact and he doesn't address that, is that fatal to his particular analysis?
It is, Your Honor. And A specific
Right.
example that we're arguing is looking at code sections 2, 3, which
Hold on a
discuss.
second. Is two, let's see, is that the person shall not be considered to have lost such person's residence? Is that what you're talking about?
Yes, Your Honor.
Just to
And then
complete, who leaves such person's home and goes to another state or county or municipality in the state for temporary purposes only, with the intention of returning unless such person shall register to vote or perform acts indicating a desire to change such person's citizenship and residence, provided that, and it's got three factors. A, if a person registered to vote in another state, county, municipality, or legislative district of any type or sort, that person shall be deemed to have changed his or her residency. B, if a person returns to his or her original or new residence after voting or registering to vote in a different or separate jurisdiction, such person shall update their voter registration with their current residency jurisdiction in order to be deemed a valid registered elector and resident of such jurisdiction for voting purposes. And C, proof of ownership of rental or a post office or private mailbox service address within a particular jurisdiction shall not constitute sufficient grounds to establish a person's residency within that particular jurisdiction. What's the other one you want? That's 2.
it's quite a few of them, Your Honor. 3.
Person shall not be considered to have gained residence in any county or municipality in the state into which such a person has come for temporary purposes only, without the intention of making such county or municipality such person's permanent place of abode. That's 3. What else?
4.1.
If a person removes to another county or municipality in the state within the intention of making it such person's residence, such person shall be considered to have lost such person's residence in the former county or municipality in the state.
6.
If a person removes to another county or municipality within the state with the intention of remaining there an indefinite time and making such other county or municipality such person's place of residence, such person shall be considered to have lost such person's residence in the former county or municipality, notwithstanding that such person may intend to return at some indefinite future period.
And 9, Your Honor.
All right, 9 is the mere intention to acquire a new residence without the fact of removal shall avail nothing, neither shall the fact of removal without the intention.
And our argument there, Your Honor, is that those 5 subsections, those were 5 of the 8 subsections that were implicated by the evidence, the findings of fact of the Secretary in this matter. Every single one of those subsections references Mr. Blackmon's intent, his intent to remain in Fulton County. That was a finding of fact held by the Secretary that that Mr. Blackmon testified his intent, and he told others his intent was to move to Fulton County and remain there for an indefinite period of time, starting October of 2024. However, that was not applied in the conclusions of law at all, and therefore that was erroneous.
All right, sir. Thank you for that clarification. Ms.
And
Noonan?
you asked an additional question.
Go ahead.
You asked an additional question. I just want to respond to, Your Honor. You asked about is the court bound by the ALJ and the Secretary's determination of the credibility of the witnesses? And my answer, Your Honor, would be yes, so long as they are supported by the record.
Okay.
And they're not clearly erroneous. If they are clearly erroneous, then the court's duty bound to reverse them.
Okay. Thank you, sir. Ms. Noonan?
Thank you, Your Honor. First and foremost, the factors that counsel cited, they all do rely on intent, and I think those actually count against him. They may not have been headers in the initial decision, but the conclusions of law have clearly considered his testimony regarding intent and found that alone to be wanton.
Did the judge address those particular five aspects of the 15 that he was authorized to take a look at under 21-2-217?
So they're not identified by section, by code name, but like, for example, um, two, talks about if it's temporary purposes only with the intent of returning, that may not be cited, but it's clearly contemplated by, within the conclusions of law section, paragraphs, 7 to 10. Those paragraphs might not reference that specific provision, although 6 does identify that there is a larger statute that has a number of factors. That particular paragraph focuses on the ones that are evidentiary, but paragraph 7 to 10 clearly consider the testimony of intent. But a second point is you need both intent and actual removal. And here, one of the things that the court focuses on is that there is no evidence of actual removal from the Forsyth house. That's what 217A9 tells us. So, to say that 217A9, which I think is one of the ones that was listed, is not considered here because it's not named, that is that then is kind of a pedantic exercise of asking, future ALJs to just paste in the entire list of factors. The court clearly considered that there was a failure to show that he actually resided at the property, and and Judge Carrero says it multiple times. So I believe those factors were contemplated, and I think the context of the conclusions of law makes that clear. They don't need to be, listed out in a page and a half in full to be contemplated by the ALJ and considered in the decision.
All right, madam. All right, folks, give me a couple minutes. I'll tell you where we are, okay? All right, thanks.
Thank you.
Thanks for your patience. All right, folks, good afternoon again. Let me wait to get everybody everybody back on the record here, or back in. Okay, the courts had an opportunity I had benefit of your pleadings, but I wanted to review the notice of filing of the administrative record in this case, and I wanted to specifically take a look at Judge Dominic Caprierio's the ALJ's decision in this particular case. I also wanted to kind of reconsider the grounds for the, in looking at this. And as you all know, in a Superior Court sits in certiorari of the administrative judges, the agency's findings. And under 22 OCGA 22-2-5 Echo, I can only reverse or modify the decision if substantial rights of the appellate have been prejudiced because of the findings, inferences, conclusions, or decisions of, in this case, the secretary are: one, in violation of the Constitution or laws of the state, and that was one of the grounds alleged by the petitioner in this case. Two is in excess of the statutory authority of the Secretary of State in this case. Three, made upon unlawful procedures. Four is affected by other area of law. Five is clearly erroneous in lieu of the reliable, probative, and substantial evidence on the whole record, and that was a ground that was alleged. Or six, being arbitrary or capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion. And those are the three, and six is also the third ground that the petitioner alleges in this particular circumstance. From a review of you all's arguments, the pleadings that have been filed, and the record in this case, the court is of the opinion that the Secretary's decision did, in fact, properly apply Georgia law, that the final decision properly considered the petitioner's failure to update his voter registration until April of 2025, that the petitioner bears the burden of affirmatively proving his residence in Fulton County. That the final decision does not attribute the residence of the petitioner's family to petitioner. The final decision is supported by the record and is not clearly erroneous. And the final decision is neither arbitrary or capricious, given the totality of the record in this particular case. So for those reasons, which track the decision of the Secretary, I'm going to deny the petition. Ms. Noonan, if you will prepare a suitable order for my signature and send that to Mr. Wilson for his review, I'd like to enter it so that they can exercise any appellate rights that they wish to consider in the circumstances. So, Mr. Wilson, were you going to say something, sir?
I was just going to ask, Your Honor, if we could submit, I understand what your ruling is today, but I would ask if we could still submit a proposed order that you can consider in conjunction with Ms. Noonan's proposed order.
You certainly may, sir.
Thank
as
you.
long as you forward that to Ms. Noonan.
Absolutely.
Today is the 10th, so if I could have both orders, ladies and gentlemen, do you think that today is Tuesday? Do you think I could get them by Wednesday at 5?
Ours is ready to be filed, Your Honor.
Fine for us to, Your Honor.
Okay, all right. Well, if you'll submit them to me, now or tomorrow, by tomorrow morning, Mr. Kearns and I can pour over them and decide which we'd like to enter. So if you could send them in a Word document, that would be great.
Your Honor, just for clarification, did you, in addition to sending the Word document, do you want us to file it on the record or no?
Certainly, sir. You may file it. I mean, because it's a filing that you choose to for my consideration. But what I would do is just you can file it and then send us a copy of that. And then I'll enter a final order based upon whose or a hybrid of one of those two particular orders or both.
Sure.
Your Honor, just for clarification, we have till 5 tomorrow?
If you give a mouse a cookie, Miss Noonan, you should be prepared at this point in time to give me something tomorrow morning.
That's fine.
I don't want to wait till tomorrow at 5 if I can help it. I got other things I got to do. No, man, I mean, in all seriousness, the sooner you can get it to me, the better. But if you need to take till 5 o'clock, but I'm trying to kind of be sensitive to everybody's position in terms of trying to get a final order entered and filed so you all can take appellate remedy if necessary, okay?
Understood. Thank you, Your Honor.
Okay. All right, send that. So file whatever it is you need to send that and send Mr. Kearns a copy since as I indicated before, we're not an EFOP party, okay? The court, that is.
Yes, sir.
All right. Anything else, folks, I failed to address?
That's all, Your Honor. May we be excused?
All right. Thank you very much for your patience to begin with. I know we were supposed to start at 1 o'clock, but as you can see, we had a very long morning and a lot of other business. So I appreciate everybody's patience with the court to begin with. But if not, I will release everybody at this point in time and wish you all the best. And I'll enter that order as quickly as possible. Okay.
Thank you, Your Honor.
All right. Be well.
Thank you, Your Honor.
All right. Take care. All right. Bye-bye.